John Q. Public loses when he sues a hospital for malpractice. He pays the hospital's attorney's fees. But the big old government loses after it wrongfully withholds documents. And that loss is either by turning over the documents on the courthouse steps, or in judgment, you don't get it till after he proves the defendant was arbitrary or acted in bad faith. And it's twice as hard, because how do you prove an entity was arbitrary or acted in bad faith? One thing to prove an individual, how do you prove an entity did that? Virtually impossible. So I think the only change you need to make, if I humbly may suggest, is to remove on page 4, lines 3 and 4. That's it. 4 just has one word. That's the only change. Everything else, have that. Now let's talk about the two cases. I wish counsel for the government were still here, because I think two of those cases, I know two of those cases are my cases. The counsel for the government not only managed to conflate the two cases, she also managed to thoroughly mistake them. So let's talk about the second case first. The second case, a client came to me and we sued the Pulaski County Sheriff, the Democrat who was alleged to have some improper relationship with someone running a gambling den. And so my client made 4 FOIA requests on the courthouse steps. Literally. The defendant provided me the records. Mind you, by the way, the defendant hired one of these high-dollar law firms. Pulaski County, we're worried about, well, this stuff costs government a lot. You know what costs government a lot? Hiring those high-dollar law firms to represent them in FOIA lawsuits. And so that high-dollar lawyer provided me the records for 2 of the 4 claims of the courthouse steps. So when we walked in to Judge Fox and said, those 2 claims are resolved, he said, okay, then I dismiss it with prejudice. Meaning it's over, you can't refile, there's nothing to refile. So those cases, contrary to what counsel for the government said, weren't lost. Those were won entirely. Those 2 claims were won entirely. Then I asked for attorney's fees. I didn't ask for $1,000. And I wish folks would actually read the filings instead of having to play a game of telephone. Because what I wrote in there is that in my private practice, which I haven't engaged in for money in years, I asked for $1,000. Mr. Chairman, I'm worth every darn penny of it. I assure you. But in my private practice, in my public practice, I don't ask for that. And we asked for either $250 or $350 an hour. That's a going rate in Arkansas, and I welcome Senator Tucker to tell what the rate is, because I don't practice generally for money in Arkansas. So that's what we asked. And the judge said, okay, hold on. Let me put that over here for a moment. Because in the other 2 claims, he ruled against us, Judge Fox did. He was wrong, and we appealed those other 2 claims. Not the money claims, those aren't on appeal. It's the other 2 claims. So those go up on appeal. And Judge Fox says, let's wait for those cases, those 2 claims that are on appeal to come back before I go look at your request for fees. So, the fees requested out of appeal. I didn't ask $1,000, and I didn't lose. That's a trifecta of being wrong on the facts. That is in part a function of the fact that we are rushing this process. I'm not here to talk about that. The second case is a case in which I wasn't the jury, and that case took place before the 2021 change. So interestingly, what happens if you show up on the courthouse steps and they give you the records? And then it's against the state instead of against a municipality. Well, you can't go to the judge for attorney's fees because you can't get money from a court. You can only get money in Arkansas against the state, not a locality, from the Claims Commission. This is that notion, as I'm sure you're aware of sovereign immunity. So, we went over to the Claims Commission. Oh, I'm sorry. Let me tell you a little about the case. The case is that I was the I was a client. I had made a request for records of affirmative action at the law school. Actions now, but behavior. I made a request for records of behavior that the U.S. Supreme Court has now said is illegal. That's why the U.S. Supreme Court cited me in the opinion saying affirmative action is illegal. My name is in Justice Thomas's opinion. And that the research that I did there relates to the records that I saw from the state, the university in particular. The then dean of the university, the then dean of the law school, the same dean, by the way, who wrote an email right after Trump won the presidency, issuing Republicans in Trump. 3 days later, he was out of that deanship. 3 months later, he was out of law school. Yes, sir.
Ma'am, please shut that light off.
Oh, there's a light.
Thank you.